Mr. Link, can you hear us? I saw you were connecting to audio.
Yes, I can. Thank you.
Excellent. Okay. Any reason we can't start? Great. So today is December 3rd, as you probably know. We're the Board on Professional Responsibility, and we are here today in the matter of Isaac H. Marks. This is board docket number 18-BD-59, disciplinary docket number 2013-D208. Starting with disciplinary counsel, could the parties identify themselves for the record?
Miles Link, Senior Assistant Disciplinary Counsel, representing the Office of Disciplinary Counsel.
Great. Mr. Schumack?
Dan Schumack, counsel for Respondent Marks.
Great. Now, I don't know if you guys have worked this out. I assume you're going first, Mr. Schumack?
That was my expectation.
Okay.
Yeah.
How much time would you like for rebuttal?
5.
5 minutes for rebuttal. Great, if we can get the clock up. So a couple of preliminary things. First, let me just ask, this is a little non-standard. There is a beneficiary in the case who is discussed. What we would like to ask the parties to do, and we will try to do as a board, is refer to that person as the beneficiary rather than by using that person's name. And we would ask the parties to do the same thing, just because we're on YouTube and would like to minimize embarrassment or public disclosure of that person's information. And
that's completely acceptable. That is acceptable to disciplinary counsel.
Great. Thanks. Mr. Schumack, any concerns about that?
None, actually. If you notice my footnote in my reply brief, I think that would be a great idea.
Yeah.
And I'll be happy to talk to Mr. Link afterwards about possibly entertaining some motion to redact prior orders, perhaps.
Yeah, I think that makes sense. That makes sense. If you guys can work that out, maybe have a redacted public copy and then under seal a non-redacted copy.
We have no problem with that.
Great. Okay, so then, as everybody has noticed, we are meeting on Zoom. Zoom has many benefits. One substantial disadvantage is it's hard for multiple people to talk at the same time. So I will make 2 requests. First, if you're not speaking, please have yourself on mute. And that goes for my fellow board members as well. Second, if you need to, somebody just disappeared. I think Mr. Link just disappeared. He's heard this before, so hopefully this isn't a surprise. If you're having, board members will have questions. If we're having trouble getting in a question, I'll sort of step in and try to play traffic cop a little bit. But one convention we've adopted, board members will raise their hands if they have a question. If you see a board member with his or her hand up, please, stop and let that person get a chance to get into the conversation. I'm a little worried we lost Mr. Link. Carly, do you have any information about that? Mr. Link, Carly?
We can't see him yet. He may be, we assume he's trying to rejoin, but.
Okay. Well, I figure he probably ought to be here for this. So we'll wait.
He's coming in.
So close.
My apologies, Mr. Chairman. A little technological difficulty here, but I think we have it resolved.
Great, excellent. Well, with that, Mr. Shumack, please, whenever you're ready, please start.
Thank you. May it please the chair and the board, Dan Shumack for respondent Isaac Marks. We come to you today with a split decision below. And as you might imagine, my client is much more excited about the chairman's decision than the two members in the majority. You undoubtedly noticed that we have adopted almost verbatim all of the chair's arguments, with some exceptions. Those exceptions include the quantum of sanction, or the period or length of sanction, as well as one of the legal conclusions and just a handful of fact findings. The focus of my, I see Mr. Walker's hand.
Mr. Shumack, the chair, even in dissent, states that he finds the respondent's misconduct to have been serious misconduct. Does the respondent agree that the misconduct that he engaged in was serious misconduct? That's
well,
it.
We certainly agree that it was serious enough to warrant a period of suspension. We also agree with the chair's conclusion that it was not serious of a serious enough nature to merit a fitness requirement as a condition of reinstatement. Look, every time somebody is found to be in violation of misappropriation, that is, by definition, a very serious offense in the District of Columbia. The Court of Appeals thinks that is one of the worst things a lawyer can do. And that's why there's a presumptive minimum 6 months suspension for a misappropriation case in the district. We have conceded on appeal a number of rule violations. Every rule violation is a serious violation. The question is, where on the spectrum does it fall for purposes of imposing a sanction?
But you concede more than just the negligent misappropriation. You do concede a number of other serious allegations. How is it then that you find it appropriate to come down only on a 6-month sanction? That would be appropriate if all that were found were the misappropriation. You've conceded more than that. So aren't we in the sanction territory kind of necessarily beyond 6 months here?
Well, there are, without doubt, instances in precedent where sanction time has been compounded when there are multiple rule violations. We have articulated in our brief why we don't believe compounding is appropriate here. And it's certainly not mandated under any of the precedents that you escalate a sanction just because there's more than one rule violation. You can look at, for example, the 2009 Mance decision is a great example of somebody who had a prior disciplinary history where there was no aggravation imposed on Mr. Mance for his prior misconduct. And he had multiple violations just in that 2009 case. Our brief contains other instances, other cases where you've got people with multiple rule violations, and yet nobody's being disbarred. This is certainly not a disbarment case. Even bar counsel agrees it's not a disbarment case, having taken no exceptions to the report. So it seems to me that the core issues that you've got to get to today for sanction purposes is, first off, we need to get to the bottom of all these dishonesty violations, because we're sitting here on appeal conceding that those dishonesty violations, if all 4 of them are going to stick, the 3 8.4C violations plus the majority's conclusion that there was false testimony in front of the hearing, if all 4 of those stick, this is certainly a bigger case than the chair has queued it up as.
What do you concede with respect to dishonesty and dishonest conduct by your client? What does your client concede?
Nothing. That's what our brief says. There's no basis for a dishonesty violation under 8.4C.
So let me explore that a little bit with you, because one of the things that I think comes up a little bit in the briefing is the standard that the board applies when it's assessing whether or not there was false testimony in particular. What standard do you believe the board applies to false testimony? Is it de novo review, or is it deferential to the hearing committee because of the credibility aspect of it?
Well, I think there's really two separate issues. One, if there's an explicit credibility finding, you are typically reviewing that on a deferential standard. That's particularly true when it's an independent witness. Where I think we differ with bar counsel's reading is, what are you supposed to do when it is the respondent, him or herself, who's testifying? The committee takes issue with adverse credibility findings and then uses that to escalate a sanction. I believe your own case law would have that be a de novo review. If you look at what both the board and the court did in Ray Anderson, treated that as de novo. If you look at what is our other, right, in Ray Bradley also.
So one of the things that, if I'm reading disciplinary counsel's brief correctly, is that their position would be that whether or not the testimony is false itself isn't what is reviewed de novo, but instead whether or not it was intentional and thus sanctionable. And so I'm just wondering what your response is to that, and sort of what support you think there is that as a board we can review what I'm kind of phrasing as the threshold question of whether or not the testimony itself was false to begin with, before we get into intentionality.
Well, I think it's still at a de novo standard because it's a legal conclusion on whether the testimony is false. And if the basis for why they're telling you it's false is because we sat here, we had the opportunity to review demeanor, and here's what we think about demeanor, well, then I think you'd have a much more difficult task to try to overturn that type of decision. The problem here is that the majority has given you no demeanor evidence at all. And I would suggest to you that you've got to fish through this decision really hard to figure out what it is exactly the majority is even talking about with respect to false testimony. If you were to look at the hearing majority's report at pages 139 through 144, they spend an awful lot of time talking about what bar counsel argued constituted false testimony. And they came out against bar counsel on a half a dozen arguments. And the only one that stuck was one of them. And that one is this notion that my client testified in front of the auditor master in 2013 and couldn't recall a lot of detail regarding his interaction with the bank teller. And yet, oh my, here he comes in 6 years, 7 years later, the hearing committee, and suddenly he can remember there was a female teller, and he claims to be able to remember other details of the interaction with the bank teller. What's curious about that is that's it. That's what the majority says constituted the be-all and end-all of the false testimony in front of the hearing committee. And to get there.
Well, no, that's not quite right. I mean, I'm looking at the paragraph you directed us to, right? It's, despite his inability to recall details of the transaction in June 2013, He provided in his testimony in the disciplinary hearing a highly detailed account of the events, including the physical appearance of the teller, which is more than just her sex or gender, and the purported lack of involvement of other bank officials. I mean, that does look, sort of beefier as a discrepancy between, and one would think that your memory doesn't get better with time, right? Like it is weird to have more detail later than you had earlier.
It is beefier. There's no doubt about that. But is it inaccurate? There's really no evidence in the record to tell us that it's inaccurate. The hearing chair goes to great lengths to note why it might be beefier. For example, guy's got his license on the hook here in front of the hearing committee. He's got 7 years to try to figure out, what was I talking about? Who did I meet with? Who was my teller? There are many reasons besides dishonesty, but more importantly,
well, like what? What other reason besides dishonesty could account for this sudden influx of detailed recollection after a number of years?
Well, it's not sudden. It's 7 years where he has been going back to the same bank, potentially. He may have been interacting with the same teller after 2013. We don't know that because it didn't get asked of him. What we do know, though, is that the majority is looking at this supposed bank record of the transaction itself. And they're reading all kind of detail into that transaction record that isn't actually in the transaction record.
Let's look at some of the other instances of dishonest conduct here. Specifically, first, in connection with the August 2012 response, your client's August 2012 response to the motion to remove him as trustee, where he said that the guardian refused to provide him with the property tax statements, thus resulting in delinquent payment of the taxes. So that's quite an affirmative statement that she refused to provide it. It's not just a kind of, he didn't recall whether he didn't think she provided it or she didn't provide it. So what is the record and the evidence that he actually recalled that Ms. Walker refused to provide those statements? That's just not true, that she refused to provide it. So where did that come from, if not something that your client made up dishonestly?
So here we have, this is the instance where the chair says this is a reckless statement.
I understand that. How is it anything other than intentional to say that she refused to provide them? There's certainly no basis for that. Where did your client come up with that statement?
Well, this appears to be something that he wrote off the top of his head. That's the chair's take on it. That was, I believe.
What is your client's take on it and your take? I don't want to hear the chair's take. I want to hear your take.
Well, our take on it is you've got a record here that has my client making a hyperbolic statement without having gone and looked at his own records before doing it.
What does hyperbolic mean? Does that mean false?
No, not always. Sometimes.
Doesn't it mean false here? If she did not refuse to provide them, there's a difference between not recalling whether she provided them, or not having provided them. A big difference between either of those and affirmatively refusing to provide them. Right. So hyperbolic seems to be a substitute word here for false. No?
Well, that was not my intention. If I could phrase it differently for your benefit and mine. I've got a client who went on record in a pleading. There's no dispute about that. And he made a statement that turned out to be completely inaccurate as compared to what was in his file. What's interesting here is it doesn't appear to become evident that that was so until the disciplinary case. He's not called on that, as far as we can tell from this record, in the probate matter. When he testifies in front of the auditor master in 2013, the auditor master doesn't take him to task for what the auditor master thinks he had in his file, because it's not apparently in the record at that point.
I'm not sure how that's relevant to us here, that it didn't come up until the disciplinary hearing.
Well, if I may,
You may.
had he been crossed on it at the time in 2013, he may have been able to do a better job of explaining the discrepancy in 2013. What he's doing in front of the hearing committee is conceding that he made a mistake. He wrote a pleading off the top of his head, which turned out to be completely inaccurate based on what was in his file.
Well, why isn't that just he made a dishonest statement, but it's not a big deal?
Well, it may be that, right? And that depends on how much intent you want to read into it. The chair views it as a reckless problem. I argued it was a negligent problem. And I think the difference here between my take on it and the hearing committee majority's take is the majority reads these other three events into the same statement, right? The majority reads, well, you know, it wasn't just the tax bill, it was a tax assessment. It wasn't just a tax bill, it was an insurance statement. But his actual statement in the pleading is limited to the tax bill. It's not about an assessment. An assessment isn't a bill. It's not about paying the insurance. And it's not until he gets notice of a foreclosure sale that he becomes aware that he didn't actually pay the taxes that were due. But I agree with you, that, Mr. Chair, that one of the issues here is, how significant is it? If it was untrue, and it's certainly inaccurate, you want to call it untrue, that's fine. You want to call it false, false and untrue are technically synonyms, except in our disciplinary system, we tend to ascribe bad things to the word false. He got it wrong. There's no doubt about that.
What about the statement when he wrote that the withdrawal of the $1,750 was to be confirmed? What, in fact, did he know about that money at the time he wrote that? Didn't he know that the money was not withdrawn for the benefit of the trust at the time that he wrote it was to be confirmed?
Well, he doesn't even seem to know what that money was at that point. It doesn't look like he's done enough digging in his own records, and you can fault him for that, right? That looks like just another neglect problem that he's got, that he didn't figure that out in time for the filing that he made.
Did you say just another neglect problem?
Well, I said you can look at it as just another neglect problem. I'm not telling you you are required to. You're obviously the adjudicator here, not me. But this is an instance where he went on record pretty fast after figuring out that the money was withdrawn. The record here seems to be very clear that he was surprised to find out that there was money withdrawn. And he very quickly, after filing that to be determined statement, was able to explain it accurately to the probate court. I've run out of my 15 minutes by quite a bit here. I would still like some time for a rebuttal, if I may.
No, you've got 5 minutes. You've got 5 minutes.
I'm happy to take any other questions you all have for me.
Why don't we hear from Mr. Link at this point? We'll come back to you for your 5 minutes.
Thank you.
For rebuttal. See, we've got 20 minutes on the clock. Mr. Link, whenever you're ready.
Thank you. Mr. Chairman, can I reserve 2 minutes after, well, if not,
yeah,
I guess my learned friend will get the last word. I just wondered if, okay, no, that's fine.
Yeah,
I wanted to, Miles Link for the Office of Disciplinary Counsel, Mr. Chairman and members of the board, on the question of dishonesty. But before I begin, I'm a little surprised that my learned friend said there was only one instance of dishonesty. If you look at the hearing committee report and section 4, Mr. Marks violated rule 8.4C in his repeated false representations. That goes on from page 124 to 132, and it notes repeated dishonest statements by Mr. Marks to the auditor, to the court, and to the hearing committee, which led the hearing committee to conclude that in light of those factors, a fitness requirement was necessary in this case. I want to start by pointing out we shouldn't forget the context of this case. This respondent was asked by the settler of the trust, whom he knew, who trusted him to be successor, to prepare the trust documents. He would be the successor trustee when she passed away. He became the successor trustee for a brain damaged, developmentally disabled beneficiary of the trust, whom he also knew, who lived in a substandard, dilapidated housing, who needed a special needs trust, who needed help and assistance. And he failed to provide that. He failed so dramatically that the court had to remove him as trustee. So that's the context within which we're finding this here. If I may, just one other point. It's important to note that in their reply brief, the respondent for the first time affirmatively states they are not contesting the violations with respect to Rule 1.1a, 1.3a, 1.3c, 1.15a, that's the negligent misappropriation, 1.15c, and 8.4d. So the only issue on this appeal—
our vice chair was trying to get in.
I'm sorry, Ms. Pittman.
It's okay. I wanted to actually go back and return to where you started, which was the dishonesty issue. And I do think, in fairness to Mr. Schumack, he said there was one instance of false testimony, because that was where I was leading him down in my questioning. And I'd like to actually start with you on that as well, which is that I think it's important for us to get the standard that we need to apply correct. And if I read your brief, you're stating that the standard that the board uses for determining false testimony is that we accept the finding of false testimony because of the credibility determination from the hearing committee, but that we can review de novo whether or not that false testimony was intentional or not. And I'm wondering, given the that Clayman has been issued recently, where there the court accepted and adopted a board's finding or conclusions that it reviewed de novo whether or not testimony was false. And if you can recall, in that case, the hearing committee found testimony was false. The board reversed on that, and the court agreed. So given Clayman, can you just kind of talk me through what standard you now believe we apply for the false testimony issue?
Well, and as the board knows, In re Wallace, which is now before the court, raises this issue again. The Office of Disciplinary Counsel believes that the jurisprudence of the Court of Appeals is clear that, by and large, it is the board's responsibility to defer to the credibility findings of the hearing committee. In re White, the board held that, in fact, the court held that the board must accept the hearing committee's factual findings if they're supported by substantial evidence, and that such deference to the hearing committee's factual findings and credibility determinations are especially heightened when the determinations are based on direct observations of the respondent. Here, if I may, the hearing committee made direct observations of the respondent, and they did make inferentially credibility findings. If I may quote from their report on page 129, a majority of the hearing committee finds this blaming of others for his own inaction to be a consistent feature of Mr. Marks's response to disciplinary counsel's charges and something that significantly undercuts his credibility.
I think Ms. Cassidy, Mr. Link.
Mr. Link, I do actually have a question for you. So when you were citing the standard, you talked about how the hearing committee, or excuse me, the board defers to the hearing committee if there's substantial evidence to support their position and findings around credibility. So what is the board to do when the hearing committee does not make substantial findings when instead they make argument or they endorse disciplinary counsel's argument rather than actually making a finding of fact? What do we do with those situations?
Well, the hearing committee, in fact, does make findings of fact when it found that the testimony of respondent was inaccurate and untrue or false. Now, and then the question becomes one of judgment based on their observation of the respondent. Do they think that testimony was deliberately misleading? The argument that it can be recklessly dishonest is an interesting argument, but all members of the hearing committee felt that testimony was
Mr. Lincoln, I think
if you will.
Walker,
and so
Mr. Walker's
Mr. Walker?
Yeah, Mr. Link, I want to get to that testimony. And so we're talking about the withdrawal of the $750 here. And so the majority of the hearing committee found that the respondent's testimony on that subject was intentionally false. Yet they relied largely on his testimony on that subject and on the events surrounding that withdrawal to find that, to make their findings with respect to failure to find reckless or intentional misappropriation. Doesn't the hearing committee seem to be at cross purposes there? On the one hand, they rely on that testimony of the respondent to make a determination with respect to the level of mens rea there, but on the other hand, they find that it was intentionally false testimony. How can you reconcile those two things?
I think that what the hearing committee had to do was to try to discern, given the conflicting testimony of respondent himself, what had actually transpired and what had occurred. And in fact, if you read that section of the report, they go to great lengths to try to discern what had happened, nonetheless concluding after their independent review of that testimony that the testimony was false with respect to the assertions made by respondent. The hearing committee was in an interesting position trying to discern what had happened. Respondent, having taken the money from the trust account, it wasn't until the withdrawal from that trust account was disclosed and revealed, after he had said that it was to be confirmed, that he then, after the fact, tried to, if you will, clear it up and return the money. And what he knew and when he knew it became a matter for the hearing committee to try to pull from the record before it. And we think the record clearly supports their conclusion. The fact that one member of the hearing committee had a different conclusion doesn't undercut the question which this board has to determine whether there was substantial evidence to support the majority's finding. That is the hearing committee's decision. The hearing committee acts through a majority of its members. And if that decision is supported by substantial evidence in the record, the fact that members of the board may have a different view, the fact that one member may have a different view, does not undercut the substance of the hearing committee's finding. If I may.
What about the fact that the majority, on the one hand, has a view, but on the other hand, has a different view of the same testimony? Doesn't that create a problem for the board in evaluating their finding or in agreeing with their determination that that testimony was false? There's an internal inconsistency within the majority's reasoning itself, isn't there?
Well, what I would characterize it as, the majority is using has to use the testimony it receives to apply it to different factual situations it's presented to it. So in one context, the testimony may be helpful. In another context, the testimony, if it's clearly false, needs to be determined as clearly false. I also wanted to cite to the In re Appler case for another case where the court held that the board should defer to the hearing committee's determinations of credibility with respect to the respondent.
But the hearing committee is saying that the same testimony is both true and false. Like that can't be right, right? Things are not both true and false. And I don't understand how you seem to like it when the testimony is true for the negligent misappropriation, and then you don't like it if the testimony is true for the dishonesty, and that's weird. Like, what do you do with that?
I don't think,
Mr. Link, in bringing that home to the standard we need to apply, when the hearing committee is saying it's both true and false, how does that equate to substantial evidence?
I don't think we need that testimony to determine the negligent misappropriation. There's no question, and in fact, the respondent is not contesting the finding of negligent misappropriation here. So I'm not sure that testimony.
But doesn't it go to the sanction?
The sanction, we do need to discuss the sanction.
So let me ask this. How is this a case where a fitness requirement is appropriate? How would fitness even work here? What evidence is there that fitness, in the future, that fitness would be an appropriate part of a sanction, or that it would have really any useful purpose here?
That's clearly what we need to discuss. And disciplinary counsel wants to be clear. There's no case that directly supports a fitness requirement where you have a respondent with no prior discipline violating, in this case, 8 rules, 6 conceded by respondent, 2 more found by the committee in a single client matter. We cited the 2 cases, Hutchinson and Midland, for the proposition not that they supported a fitness requirement, but that they supported a substantial suspension, an 18-month suspension. That's why that's a C citation, not a direct citation. So the question becomes, why do we have a fitness requirement in this case? And the hearing committee's view is respondents' repeated false statements to the probate court, false testimony to the hearing committee, gives the majority serious doubts about respondents' apprehension of his duty of honesty to the tribunal and consequently his ability to behave ethically in the future.
So, Mr. Links, let me interrupt
that is the hearing committee's rationale in support of a fitness requirement.
Mr. Links, I'm going to interrupt you right there, which is, if the board were to determine that some of those false statements were not false, or that they were not intentionally false, given that it is the false statements and the false testimony that is the support for fitness, would it be your office's position that fitness would no longer be appropriate?
No, because so my short answer is no. My longer answer, though, is when we're talking about the sanction, we should be clear the only issue here, in our view, is between 18 months fitness and the CLE requirement and the 12 months and the CLE requirement that the minority supported. The respondent essentially adopts the minority committee's report with, as my learned friend said, a few minor exceptions. So we're not talking about a 6-month suspension. We're talking about either a 12-month suspension without fitness or an 18-month suspension with or without fitness, both the 12th and the 18th having the CLE requirement. So the question is, if you don't find dishonesty, should you still find fitness? And we would argue that you should, because the other issue is the 1.3b, intentionally failing to seek the goals of the trust. And that is the issue where the board made some very, very deliberate findings. The board found, for example, that he
Mr. Link, I want to ask you, I actually had a question about the 1.3B1, and I want to focus my question on the finding about the payment, or the loan repayment by the pastor. Comment 1 to the rule says that a lawyer has professional discretion in determining the means by which the matter may be pursued. Here, if I've read the record correctly, we have evidence that the respondent approached the pastor and his wife in 2010, and that the conversation was very contentious, that thereafter the respondent consulted with his colleagues and reached the decision that litigation would not be worthwhile here for a variety of reasons. So my question for you is, how do we determine where to draw the line between the exercise of professional discretion, which can always be second guessed in hindsight, and an intentional failure to pursue the objectives of the client, which here is complicated by the fact that the respondent really didn't have a client that was directing him?
Well, exactly. The respondent was a trustee, just like a bankruptcy trustee faced with a difficult creditor has got to pursue whatever remedies are available. So this trustee had to pursue. The discretion he had was how to pursue the loan. Litigation may not have been the appropriate way to pursue it, but there were informal remedies he could have pursued. He knew other pastors who knew this pastor. And in fact, we know for a fact that when the subsequent trustee pursued other remedies, he was able to get the loan repaid. So the failure of this trustee to do anything to see that that loan was repaid undercuts any claim that that was an appropriate exercise of discretion by a trustee under these circumstances.
That's not the record. He didn't do nothing. My understanding is that the hearing committee, and I'm quoting, the lack of sufficient diligence is what they found here. It's not that he did nothing, and that brings me back to my question of where do we draw the line?
I think you draw the line with respect to when you're exercising discretion as a trustee for a disabled beneficiary, you don't simply take half steps. You may determine that full-blown litigation is inappropriate, but the board and the hearing committee have to ask yourself, is simply one conversation or maybe two conversations with the pastor sufficient? There are other informal remedies we all know as lawyers that can be pursued to collect a debt. He pursued none of them. That cannot be the appropriate response for a trustee under these situations.
Let me ask you this though. What's the distinction then between a 1.3A violation and a 1.3B?
Well, I mean, the 1.3B, the 1.3A is, do you have the capability? Do you understand what your duties are? 1.3B
shall zealously and diligently represent the client.
Right. And 1.3B, the goals of the trust were to amass a suitable corpus that could provide for this beneficiary and ultimately create a special needs trust for this beneficiary. And in the meantime, make sure that the property was kept and maintained in a suitable condition and that the beneficiary was taken care of. None of that did he do. He failed to pay the property taxes due on the property. That's findings of fact 112 to 116. He failed to maintain the property in a suitable state for the trust beneficiary to live there. That's findings of fact 88 to 96. The respondent takes no exception to those findings of fact. He failed in his duty as a trustee, and these were all deliberate actions he took. I mean, these were all decisions he made. You cannot look at this and say he understood what his responsibilities were and he somehow mislaid the purpose. These were intentional and deliberate disregard for his duties as a trustee. Ultimately, they led to his removal. They were among the factors that led to his removal as a trustee, but they are also the factors that led the hearing committee, and we think the board should also conclude that he violated intentionally the terms of the trust. He did nothing to ensure that the trust goals and purposes were met under his watch.
Got 10 seconds. Do you want to conclude?
I just wanted to conclude that in light of the findings here, the only issue again is whether a 12-month suspension versus an 18-month suspension with fitness. In both instances, there are CLE requirements that should be imposed. And the only sort of rule violations at issue are 1.3B. One, we think it's clear for the reasons stated that the violation has been shown. And the 8.4C violations, there are multiple instances of his dishonesty. It's interesting, the minority opinion goes to great lengths to try to excuse every instance of dishonesty and call it reckless or unintentional or forgetful. And even my learned friend tries to excuse it as neglectful, as if somehow an attorney's neglect of his responsibilities is an appropriate defense under these circumstances. We think it's not. We think the hearing committee got it right. They saw Respondent, they listened to him, they saw the record. And by the way, the list of exhibits, it's not with respect to the tax matters, it's not just DX 114 and 115. There are multiple exhibits, multiple instances where the guardian provided the Respondent as trustee with tax-related information, and he simply ignored it, and then he tried to lie and say he never received it.
Got it. Okay.
The record is clear on these matters.
Thanks. Could we have 5 minutes for Respondent's counsel? Mr. Shimak, when you're ready.
Thank you. I want to make sure I have some discussion today about the appropriate sanction because we're not getting there on the first 15. So let me start there, and if I still have any time left, I'll use it to comment on Bar Counsel's argument. You've got a very recent case that you all have issued, In re Kennedy and Dolan. You released that about a week after the briefing closed in this matter. So about a week after I filed my reply brief, you all came out with In re Kennedy and Dolan. My view is that your work on the Dolan case forecloses any pretense that a fitness requirement should be imposed in this docket. You noted the real skepticism standard in Dolan, and it's just stunning to me that Bar Counsel is hanging on to this argument for a fitness requirement in this case, particularly if you're going to mark down any of the dishonesty or false testimony conclusions from the majority. But my suggestion to you is that Dolan is a good decision on your part, and we certainly like what you did in Dolan and would like to apply it here. I don't agree that this is a choice between 18 months or 12. We have briefed and made an argument for your consideration that would justify less than a 12-month suspension period. And we hope you will take it seriously because we were serious in the way we wrote it up. We've given you citations that you can use if you wish to impose less than a 12-month suspension. I agree. I believe it was Mr. Walker who asked me if it's is it not required or at least not customary to see compounding, and it certainly is. I think it is a normal thing in the disciplinary system to see a compounding of sanction when multiple violations are involved. But as I've shown in our brief, it's not a requirement in the disciplinary system. And I argued on the brief of the opening and the reply reasons why this is not a case that merits any kind of substantial compounding. Starting with the argument that this misappropriation case is not one that is substantial in character. It's a relatively small amount of money. It's a relatively short period of time before it was discovered and corrected. It's not the crime of the century as misappropriation cases go, and it's nowhere near the Robinson case that we offered to you, which only resulted in a 7-month suspension despite 3 years to detect and correct misappropriation after that particular lawyer had.
I guess I've got a question for you, and maybe this is Mr. Walker's question, and I didn't appreciate it fully, and you've already answered it. But it looks like this is not just a case where there are a bunch of rule violations, and the rule violations, sort of apply to the basic same conduct, and it, sort of overlaps with a bunch of different rules. It looks like this is a case where even on the stuff you've conceded, there are separate, real, substantial problems, right? The negligent misappropriation, and I guess, perhaps if the false statement is negligent and not just reckless, and you haven't conceded that, that's separate. But, like making a false statement is a separate bucket than misappropriation, and they're both a separate bucket than, 1.3 violation. I guess that seems to pull it out of the cases that you cite in your brief, and makes it seem like, perhaps increasing beyond just the bare minimum for the negligent misappropriation sure looks appropriate. That's the end of my question.
Well, I'm sorry you see it that way. I think there's some validity to your position that these could be separated at least rule violations.
In that regard, let me ask if there is another set of charges to add to that litany, and that is the 1.3b1 allegations, or I should say findings, with respect to your client's failure to find safe living conditions for the trust beneficiary and his failure to pay property taxes. It appears that all 3 members of the hearing committee agreed with respect to those findings. Do you concede those 1.3b1 violations as well?
No, and neither did the majority on the committee. The only thing that
the majority on the committee, or
the only finding that the majority claimed constituted a 1.3b1 violation was the failure to collect from the pastor. That's it. Everything else, they just said, well, that's the 1.3a stuff.
I think there is language to the contrary in the report.
I will respectfully disagree with you. I think the chair explains it, and the majority itself states it.
Well, I don't want to unnecessarily prolong this argument, but let's take a look here at the report.
Mr. Walker, I think Ms. Pittman had a question. Do you want to find that? Ms. Pittman can ask her a question. We'll come back to you.
Yeah, please go ahead.
It's actually, I had a very similar line of questions as this. And so perhaps short of finding it in the report, Mr. Shumack, I just want to make sure that I understand it. If we read the majority decision as having, because they do kind of lump rule 1.1, 1.3a, 1.3b, and 1.3c as sort of one heading. And then they list these 4 things: the failure to provide the accounting for the trust for those years, the intentional failing to pursue the pastor for the loans, and failing to have a safe place, failing to pay property taxes. Those are the 4 things if I read that section. And then the dissent only refers to one of those 4. And then in your briefing, you make the argument that the reason the dissent only refers to that one is because that's the only finding that is actually connected up with the 1.3b.
Right.
If we were to disagree with you and find that the majority found those other things were also 1.3b violations, is it your position that you're not conceding those?
Well, that's correct. And if I take it page 98 in the committee report,
Let me draw your attention instead to page 105 of the committee report. And this has to do with having the allegations having decided to hold on to the house while the market improved. However, Mr. Marks owed an obligation that he violated to make sure that the beneficiary had a safe place to live. That's on page 104. On page 105, the report states, we find that by intentionally abdicating this responsibility, Mr. Marks violated obligations to the trust to affect the settler's intent and the beneficiary's interest, and in doing so, violated disciplinary rules 1.1a, 1.3a, 1.3b1, and 1.3c. That's pretty clear. And you will find statements to the same effect on page 110 with respect to a violation of 1.3b1, with respect to the conduct in connection with the failure to pay property taxes by the respondent. I don't think the report could be plainer that 1.3b1 violations were found in those two instances as well. So do you concede those violations?
No. No.
Did you even know about them?
Well, I see what you're pointing me to, and I may need to give you some follow-up item in writing. My read on this report was that the only thing that the hearing committee concluded was a 1.3b1 violation was the collection issue.
So to what I think was Ms. Pittman's point, first of all, it appears to me that all three members, that there's no disagreement from the chair in his dissent with respect to those findings. So that having been the case, doesn't that take us out of the 6-month suspension sanction range?
I would say no. We've got cases where a 1.3b1 violation is routinely something that would obtain with a very short period of suspension. We've got instances of 1.3b1 cases that are routinely given a reprimand, sometimes a censure. They're not automatically suspendable offenses.
Why don't, Mr. Schumacher, we're well past time. Why don't you take a few seconds and sort of give some concluding remarks, and we'll.
Well, thank you, Mr. Chair. We've briefed the case. I will, Mr. Walker, take another look at the passage you pointed out. I will follow up with something if I think it's appropriate to give you further comment on it, assuming you all are willing to accept a subsequent filing. You may assume that I still disagree unless I file something by way of concession. We have here a case that simply was not proven in a way that would justify a fitness requirement, a case that was not proven in a way that would justify an 18-month suspension. I would suggest to you that even if you are inclined to buy into some of the 8.4c violations or the dishonesty in live testimony findings that, as the chair had suggested, maybe they're not that impactful. Maybe they're not that material to what was really in play here. I'm asking you to come back with a set of findings, conclusions of law that are in line with the hearing chair, except to the extent that I've disagreed with the hearing chair on the reckless dishonesty charge. And I would also ask you to come in below the hearing chair's recommended 12 months suspension.
Okay. Thank you very much,
Mr. Chairman, if the board entertains a subsequent filing from respondent, will you also entertain a response from the Office of Disciplinary Counsel?
If somebody wants to file a motion to file something, they are you know, everybody knows how to file motions, right? Like, I'm not saying we're going to rule on it. I'm not saying we're going to deny it, or like, you know, there's a process, follow the process. Cool. Thanks.
Fair enough.
The
Thank
case
you.
is submitted.
Thank you.